Mochi Health is here to help you start your weight loss journey with caring, personalized support. Meet one-on-one with board-certified obesity doctors and registered dietitians who truly listen and understand your unique needs. Eligible patients can access affordable GLP-1 medications delivered right to their door each month. No insurance? No problem. Mochi Health accepts FSA and HSA, making care accessible and affordable. And with 24/7 customer service, you'll never feel alone on your path to better health. Get started with Mochi Health today. Take the free quiz at joinmochi.com and use code AUDIO40 at checkout for $40 off your first month of membership. That's joinmochi.com with promo code AUDIO40.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my frozen co-host, Brett.
Hi, Alice. It is very frigid, but I'm trying to make it, nevertheless.
Nevertheless. Well, Brett, on this frozen, chilly day when kind of sub-zero temperatures have gripped the entire nation, guess what's hot? True crime, and specifically the Murdaugh case. There was a hearing this morning about a topic that has sent kind of the true crime world ablaze, and that is allegations of jury tampering by the clerk of the court, Becky Hill.
That's right, Alice, and we've talked a lot about this over the last few months, ever since it first popped up. It was a bombshell filing by the defense when they made it. A lot of credible allegations that, if true, could potentially lead to a new trial for Alex Murdaugh. And a lot of people wondered how that was going to go, and we're getting more and more clarity. As we've talked about before, there's an evidentiary hearing at the end of the month that could last up to 3 days. Though after what we heard today, I'm not sure that's going to happen. Well, it'll happen, but I'll know that it'll last 3 days. But today there was a hearing to sort of lay out what the rules would be and how that would go. And I got to say, today was a tough day for the defense. They took a lot of hits, and the hill that Murdaugh's going to have to climb got steeper and steeper the longer the hearing went.
Yeah, absolutely. So this first hearing, really, this is just a preliminary hearing laying out kind of the rules of the road for this subsequent hearing that's happening at the end of the month. And the first thing to note is the judge that's presiding over this particular aspect of the case. So as we know, there's evidentiary issues, and the judge who presided over the Murdaugh trial has recused himself, and in his place is a retired judge, Judge Toll, who sat over today's hearing and will sit presiding over the evidentiary hearing at the end of the month. Some of you may be thinking, why would the judge who knows all the facts of the case from the trial not sit in on this one? Well, if you remember the defense's filings, there are some allegations that judge may have some knowledge about facts that are going to be at issue. And so we have had legal briefs on this before. We found that the judge didn't need to necessarily recuse himself, but I don't necessarily think it was a bad idea for him to do so because of all the attention around this case, that it's almost a damned if you do, damned if you don't situation. But by staying out of this completely, there will be no allegation that he's having to preside over facts that he may have personal knowledge over.
And I think after Judge Toll finished today, I kind of wonder if the defense wishes they hadn't moved to remove Judge Newman or to recuse him. Judge Newman, a very patient judge. I think there was a feeling that after sitting over the trial, he had some sort of bias against Murdaugh because of everything he'd seen. I don't think that's true. And I think the thing about him, he often ruled in the state's favor, but he also let the defense waste a lot of time, I thought. I wouldn't say he's a defense-friendly judge, but he was a very sort of laid-back judge who allowed them to do a lot of things that I don't think he necessarily had to do. This judge seems like she is very matter of fact. She has a very defined way that she looks at this hearing, and it's a narrow way of looking at it. As we talked about, when this initial filing was made, there were a lot of very broad accusations made. And we talked about Egg Lady, for instance. As we said in one of our earlier episodes, Egg Lady was included in the filing as much as to make it more sensational than anything. Everybody knew who Egg Lady was. She has the most sensational claims. But when you looked at the claims, it didn't really feel like those were the kind of claims that were going to be successful. They grabbed a lot of attention, but they didn't seem like they had a whole lot of merit to them. And this was discussed at length today in the hearing. And one of the decisions the judge made that I'm curious what Alice thinks about is that Egg Lady will not be testifying, at least as of now. It's possible that later on she could become more relevant, but the judge has taken a very narrow view, the view that we sort of expected her to take, which is this is all about whether or not those 12 jurors who went back to deliberate were influenced or not by something improper that Becky Hill did. And that's the only question. What happened to Egg Lady and all the Egg Lady stuff, at the end of the day, didn't really go to what those 12 people decided, which was that Alex Murdaugh is guilty. And so the judge said, right now, I'm not going to get into that. This is not going to be the trial of Becky Hill and every bad thing she ever might have done. This is going to be about those 12 jurors, what they heard, and whether or not it affected them.
I think that's exactly right, Brett. We talked about how the defense's filing to show that they needed an evidentiary hearing about jury tampering was filled with a lot of potentially, firebomb types of accusations or allegations that, if true, would be very, very promising for them to get a new trial. But at the same time, while we said that there were very serious allegations in that filing, there was also a lot of fluff. It was a lot of spaghetti at the wall types of allegations. And in that sort of way, you have to narrow what you're looking at. And this judge was not going to allow them to spend 3 days, for example, talking about things that ultimately would not matter with respect to whether Murdaugh got a new trial. And I think it's right about Egg Lady. Egg Lady ultimately was not one of the 12 who voted to convict Murdaugh. So whether she was influenced by Becky Hill actually doesn't matter for purposes of the ultimate question. Did the voting jurors who voted to convict Murdaugh, were they swayed in a way that was improper by something that Becky Hill said? And, that's not the only ruling she made there. There were a lot of questions because the defense's first filing about these allegations had, if you remember, attached affidavits, both sworn affidavits as well as unsworn affidavits from jurors, and even affidavits from attorneys who had talked to jurors and talked about what the jurors had told those lawyers. All to say is there was a question as to whether any of the jurors or all of the jurors would have to testify. And Judge Toll was very clear about that in today's hearing. There was a lot of legal argument, a lot of citations to law and what the Supreme Court of South Carolina allows and doesn't allow. And she ultimately said no jurors at this point are going to testify at the evidentiary hearing. Brett, what do you think about that?
And I think what she means by that is, to the extent there's any questioning of jurors, it's going to be her. I mean, she's the one who's going to do it. It's not going to be Poot cross-examining these jurors. And to the extent that at the end, some of the jurors have hired attorneys, and the attorneys are like, we don't even think we need to be involved in this anymore. If it's going to just be the judge questioning the jurors, we're fine with it. We're not concerned. If it was going to be Harpootlian, they were going to be concerned. And I think they would have wanted to be there. But as it is, the judge is going to collect some questions from the prosecution and from the defense and is going to question these jurors on her own. It'll be public, but on her own. I mean, she's set it up where there's going to be privacy for the jurors. She talked about how court TV is going to have to be sure not to show them, but that's not going to be like you see at a trial. It's not going to be someone getting up and getting cross-examined. That's not how it's going to go. This judge is going to ask questions, and the judge said she feels very confident in her ability to judge the credibility of these jurors and what they tell her. And if those 12 jurors get up there and basically say, either Hill didn't say that or I didn't hear her say it, and whatever she said, it didn't affect my verdict, that's going to be the end of this. And the reason I say that, because the most important thing the judge did today was her first ruling, where the attorneys argued back and forth about what the standard's going to be. And we talk about this a lot in our various legal briefs, whether it's about this case or other cases. It's really easy to get caught up in the sensationalism of cases, the facts, the stories that you hear from various sides, the sensational filings. I mean, in this case, the defense has made a lot of filings that made a lot of allegations, including all sorts of things that Becky Hill said or did. You know, she talked about how a guilty verdict would help her sell books. And Harpootlian mentioned that at some point, and the judge was like, that's the last I want to hear that, because that doesn't have anything to do with whether or not this jury was influenced or not by Hill. And, you know, she sent a text message to Creighton Waters saying that she thought Murdaugh was guilty. And at some point, the defense actually asked to put Waters on their witness list. They're going to put him on the stand. And the judge said, no, we're not going to have any lawyers on the stand. We're not going to have any judges on the stand. We're not going to do that. This is not going to be some wide-ranging fishing expedition. And most importantly of all, standards determine cases, because when you have a high standard of proof, it requires a lot of evidence that you often don't have. The defense came into this trying to say that if a member of the court staff had spoken to the jury about anything that was material, that prejudice should be presumed. And what prejudice means is the fact that she did it hurt Murdaugh, and he gets a new trial in that circumstance unless the prosecution can turn around and prove beyond a reasonable doubt that it had no effect on the jury, which is a very difficult standard for the prosecution to reach. And they based this on a 1991, I believe, case out of South Carolina, the South Carolina Court of Appeals, which had made some pretty broad statements that supported that. The problem for the defense was there were all these other cases, including South Carolina Supreme Court cases, that said, if you're going to allege this, you have to show prejudice. The burden is on the defense to show prejudice. And we talked about in one of our last legal briefs that this was going to be a huge decision for the judge, which standard to apply. Because if prejudice is presumed, that's a big victory for Murdaugh. And the pressure is all on the prosecution to prove beyond a reasonable doubt that it had no influence on the jury and their decision. Now, as the judge said, prejudice will not be presumed, it must be proven. So Murdaugh is going to have to show that not only, there are now two questions. First, you have to prove she said it, that she said something that was improper, and she said that to the jury. But then you have to prove that it actually affected their verdict. So even if they can show she said all the things that they've alleged that she said, if the jury gets up there and says, whatever crazy lady said, I didn't care, I decided this based on, watching him in trial or whatever. If they get up there and say that, it's going to be almost impossible for the defense to carry their burden. And there was a huge blow to Murdaugh and his team.
Yeah, I mean, I think this is absolutely the right ruling on the law. We've talked a lot about this, the need to show prejudice, not just for a new trial, but for basically any harm or foul at the trial level. And we say this because trials, there's no perfect trial. Trials are like living, breathing organisms, right? There are live witnesses. You do not know. It's not a script. This is not television. There really is no perfect way to have a trial, and there will be many missteps along the way. And if you have this kind of presumption that if any misstep by even a member of the court is enough to show that someone is entitled to a new trial, that greatly, greatly increases the chances of any defendant getting a new trial, which really upends the whole finality-ness that trials are supposed to give. You won't be able to move on to your appeals. You won't be able to move on to a number of things to vindicate your legal rights, whether you're the defendant or the prosecution. So I do think this is the right outcome based in the law as well. And one thing that I really appreciated, Judge Toll is incredibly credentialed. She is a retired former Chief Justice of the South Carolina Supreme Court. And she was appointed by the Supreme Court of South Carolina to preside over this, limited matter in the Murdaugh case after Judge Newman recused himself. She sat on the very court that heard these types of arguments and wrote opinions determining what these standards were. So she's not some young, inexperienced judge. She has seen how this has played out across the entire state of South Carolina and knows the implications that though this is one case, the Murdaugh case, which of course is being televised all over the nation, all over the world, it's not just about the Murdaugh case. This ruling could have an effect on many other standards across South Carolina and maybe beyond as other courts are looking to what she does in this case with respect to where the burden lies. And we call this burden shifting in the law, where the burden first lies and you have to be the one to overturn it or to prove up to it.
And I think who was really impressive today was Creighton Waters. Creighton Waters led the prosecution team at the trial and was very active today as well. And in that initial argument about what the standard's going to be, Jim Griffin talked for the defense because Jim's kind of seems like the real lawyer, and Harpootlian, I mean, he's a real lawyer too, but he's more the showman. So he's the showman lawyer.
He's
and
for the
Jim
jury,
Griffin is more
right? He's for the show.
He's for the jury. He's for the show. So of course Jim Griffin's the one arguing the law, and he's hammering this one case that they've got, and it's a good case for them, but there's only one of them. And then Creighton Waters gets up, and he's just going through case after case after case, some of which he argued. And he's able to say to the judge, you know, as I argued in front of, you know, you sat on that case, Your Honor, and as we argued, this was the standard, and this is the way the Supreme Court came out, and that's how it applies here. And it was really interesting to hear him talk about that because he's just a very impressive lawyer, because he's obviously a very good trial lawyer, but he's also a very good sort of litigator just on pure legal questions. I bet he's a great appellate lawyer, and it's rare to see somebody who has sort of everything in one package, but he clearly has it. And it was a very convincing presentation that he gave to the judge, and obviously one that the judge accepted in the end.
Yeah, I think that's exactly right. And, you know, for those of you who may be wondering, well, why, you know, what's the big deal if it were the prosecution who had to prove beyond a reasonable doubt? In a way, it's like having to prove the negative, which is almost impossible because the presumption is already that there was an effect on the jurors. And jurors, I think this was very, very smart of Judge Toll to say, yes, we can question the jurors, but it's going to be me. Now, this is not that uncommon. A lot of judges, when it comes to jury voir dire, they will actually do the questioning as opposed to letting the litigators do the questioning specifically for this reason, because we are talking about lay people. These individuals who they did not sign up to be on the jury. They received a notice to appear at the courthouse and they were picked to be on this jury. Their lives have been altered forever. But we're talking about lay people who got paid like minimum wage a day to take time off from their real jobs to sit on this jury, now having to hire their own counsel because they potentially may be cross-examined in a way that could make them vulnerable to whatever sort of crazy allegations the defense may throw at them. And because remember, all the defense cares about is Murdaugh. They don't really care about juror number 1, 2, 3, 4, 5, etc. By the way, the judge even talked about renumbering them so as to protect their identities further, since people may be able to kind of back channel from the trial who these jurors were. These people who are just citizens now have to potentially hire their own counsel and be cross-examined in a very hotly contested hearing. That is terrifying for anyone, much less a layperson who didn't even sign up to be on the jury. But they obviously have very important information that could come into play at this evidentiary hearing, and the judge is poised to kind of cut out all that showmanship and get to the heart of the question. So when a judge, I personally kind of like it when a judge does the jury voir dire, at least the bulk of it at the beginning, because you're able to cut through a lot of the showmanship and just ask the questions that matter, because you're not doing it for the cameras. You're not doing it for advocacy for a particular client. You're just doing it because there is a legal standard, which we now know what it is. And you ask the precise questions to get to the facts that will matter for that legal standard and nothing more.
And I think there's a couple things that are important to remember. Jury secrecy is important. You want jurors to feel like they can say just about anything they want in the secrecy of the jury room when they're making a decision and never be called into question about it again, because you want them to be forthright and you don't want them to hold anything back to reach a good decision. We really believe in that, about that in this country. They talked about that some in this hearing. They talked about some of the rules that apply to that. And the judge made it pretty clear that she's going to protect that. She's really only going to ask questions about this improper influence. You may recall that in the defense's filing, they talked about how one of the jurors was pressured by other jurors to find Murdaugh guilty. That is not an appropriate thing to inquire about. That's deliberation when jurors talk to each other and come to a conclusion. You don't just walk in and have a vote, and if it's 12 to convict, you convict him, and if it's 12 to acquit, you acquit him, and if it's 10-2, then we have a hung jury. That's not how it works. You talk about it, and you talk through it. We're not going to get into that. I think the judge is going to protect that. The second thing, as Alice said, these jurors, they didn't ask for this. They're not criminals. They're not witnesses to a crime. They're not on either side. And as we've talked about a lot, truth, there absolutely is truth. We're not saying there's not truth. But people, when you're asking people questions, depending on how you ask them questions, their answers will change based on sort of their perception of you, what you're asking, and how it's going to affect them. And you see this if you just watch a witness on the stand. A witness typically, unless they're hostile, is much more open with the side that calls them. And then on cross-examination, even if the person crossing them is nice and doesn't attack them, they get defensive, they get guarded, they answer the questions in a different way. The judge doing this takes a lot of that away. Because really, we all see this as the state wants to uphold the conviction, the defense wants to undermine it. But in reality, everybody wants a good conviction constitutionally made. And so having the judge, who's a neutral arbiter, who the jury will see that way, they won't see the judge as attacking them. I think you're much more likely to get sort of open answers without any of the shading that you might get if all of a sudden Harpootlian is going after you in cross-examination. You can imagine jurors might react negatively to that. And I don't think that's the best way to get to truth in this kind of circumstance. So I think the judge definitely doing the right thing to question the jurors. If it wasn't one of the 12, so dismissed jurors and alternates, they're not questioned at all at this point. The judge left it open that the defense could file some affidavits, maybe try and show this. You know, Harpootlian kept trying to say, well, I don't know who we're going to want to call or what we're going to want to ask, because who knows what Becky Hill's going to say. That's absurd. I mean, come on. You have a good idea what she's going to say. And
she already filed an affidavit.
Yeah. You know who you're going to call.
And you've already interviewed all of the jurors, right? Here's the other thing is this hearing is happening because the defense asked for it. So it's a little disingenuous to say that they have no idea what they're going to say because they're the ones who asked for this hearing. And by the way, they got what they asked for. So it's not, you can't kind of have your cake and eat it too and say, we really want this hearing, but we actually don't know what's going to happen at the hearing. You do. You have an idea, of course, especially if it's 3 days, if something were to happen that no one was ready for. And Brett and I have explained this time and time again when we're in a hearing and something's brought up because it was late found, like literally an agent comes in and is like, I just found this information, or someone says something on the stand that has never been said before, no one is expecting it. Guess what do? Your Honor, can we have a sidebar? Your Honor, this testimony is unlike anything we've heard before. In fact, it contradicts everything that was said in these affidavits cited here. We're going to need a little bit of time in order to investigate the veracity of what's been said and how to respond to it. And you know what the judge will probably say? Yeah, this is absolutely right. Let's take a recess for the day. We'll be back tomorrow at 9 a.m. and see what you have then. That's fine. Like we said, these hearings and trial court is a living, breathing kind of organism. There are not like, oh, well, the clock is ticking. It's going down. You're running out your time. That's not how it works in trial court. There is time to react to things that you may not have been expecting before. But wanting to keep that avenue open to call jurors is because they want to make a show of it. Because the judge wants to keep this on Becky Hill. Not on whether juror number 1 was feeling a little wheezy about getting someone to go to prison and then juror 3 said something. None of that matters. And if they are cross-examined by the defense, that absolutely may be the line of questioning, even if the judge shuts it down. We've seen this time and time again at trial, even this particular trial, that objections are not always heeded. And these are real people sitting on the stand who can't just shut off their anxiety. Shut off what they're hearing that's happening. Shut off these objections. Shut off the fact that they're on camera for the world to see them being cross-examined as if what they saw. Criminals on the stand being cross-examined.
I think the judge was very wise to set this as a 3-day hearing, because she's already said she will be able to examine all the jurors in 1 day. And then you imagine Becky Hill, say she's on the stand for a full day. Well, at that point, what's going to happen is you're going to have the defense say, based on what we've heard, these are the people we need to hear from. And you've got that extra day on the back end where they can do that if they need to do it. I think that what is probably going to happen is you're going to have the jurors testify, you're going to have Becky Hill testify, and the judge is probably going to say, I don't need the 3rd day. We can make this decision based on what we've heard, because as we said, however broad you thought this was going to be based on the defense's filings, the judge has really narrowed it down to what matters. And we talked about this I talk about this on the gallery. People are always freaking out. People freak out about everything in these cases. That's what I've learned from doing a true crime podcast, is every time somebody files something, people freak out. And people were freaking out about the defense's last filing, where they were like, we have emails where Becky Hill said X, Y, and Z. And then the judge is like, none of this matters. It's completely irrelevant. You're not going to dig into everything she ever said. There's one question. Did those 12 jurors, were they influenced by somebody, or did they come to their conclusion without that? Did they come to their conclusion based on the evidence they heard? Even if she said something, was that sufficient to prejudice Murdaugh? And I think it's important for everybody out there to remember, it's so easy to fall into this trap of, well, if we're going to take away a man's life, it has to be a almost perfect trial. We got to hold everybody to the highest standards and all these other things. And I get that. I totally understand that. And we do have to hold people to the highest standards. And if Becky Hill did a bunch of this stuff and it didn't affect the jurors, doesn't mean that she shouldn't be punished for it. Doesn't mean she shouldn't lose her job. Doesn't mean she shouldn't be investigated. There may be all sorts of things that should happen to her. And if she affected the outcome, if she prejudiced Murdaugh, then yes, he should get a new trial. But this idea of prejudice is so central to everything we do in the law. In the civil world, it's all about damages, right? If you sue somebody who did something bad, something we don't like, but you can't show harm, you can't show that it had any effect on you, just the fact that they did a bad thing doesn't mean you're going to win your lawsuit. Similar in criminal law. We know that no trial is perfect. We know that the entire system is made up of humans, and humans will do dumb, immoral, wrong things. But the question that we're going to decide is, does that have an effect or not? If it didn't hurt you, if it didn't harm you, if you can't show some sort of effect on you and your rights, then just the fact that somebody did a bad thing is not enough for you to get a new trial. That's not the way we do it. And the reason we don't do it that way is what Alice was talking about. There are counterbalancing interests: finality, victims, justice, resources, efficiencies, all sorts of reasons that when you have a trial that results in a verdict, if you can't show that some sort of error had a direct effect on you, you're not going to win.
I'm feeling a metaphor coming on, and someone's going to attack me that this metaphor is completely wrong, but I'm trying to show you there's two very nuanced things going on here, and it's important to know what this hearing's about. Again, we said this at the beginning, but I think it bears repeating. This is not a trial about Becky Hill. She may have done some bad things. She's certainly getting skewered in the court of public opinion. But this particular hearing is not about Becky Hill. It's about the jurors who voted to convict Murdaugh. So imagine it this way for the legal standard. You have a pool and you have little boats. You know how you can make little paper boats? I've been watching a lot of Curious George with my kids. Paper boats, each of the jurors, 12 boats. They're all in this pool, okay? And here we have the defense screaming that Becky Hill has been splashing into that pool. Splashing, splashing, splashing. There's just water going everywhere. There's ripples. There's waves. This is just it is undeniable. Everyone, says the defense, that these splashes are happening and there's water flying everywhere. And the person who's making those splashes is Becky Hill, who's reaching and slapping her hand in that pool. Couple questions. She could be doing all those things and it could be very bad. There could be repercussions. She has a government position. She has specific duties to her position. Which pool is she splashing in? Because she shouldn't be splashing but maybe it's a different pool. Maybe it's a different pool than where those boats are. Let's say it's in the right pool, though. Let's say all those boats were going to go down one lane. It's a very delineated lane, and that it was but for her ripples and her water drowning these boats that they either drown or they go off path from the path they would have gone if not for her ripples. That is the but for her actions that they were then able to change their mind. That's what the judge is looking for here. Let's say she could even be splashing. You can imagine someone splashing in a pool, but it doesn't change the course of the boats. And that's what Brett was saying. If those jurors say, yeah, I heard her say something weird about Murdaugh, but who cares? She was talking all the time. I did not pay any attention to her because that man was guilty because of X, Y, and Z. Then guess what? Her actions did not affect that juror's decision. And so there's a lot going on here, and there's obviously a lot of things to be distracted by because there is splashing. There is water kind of going all over the place. But we need to know the effects of what she's done, if she's done it at all. And this judge has made some very specific rulings today to make sure that we stay on course and not make this kind of a show or mockery of the court for TV. That this is focused on Murdaugh's conviction and Murdaugh's conviction alone.
Another area you see this is with a corrupt prosecutor or a corrupt police officer who does something improper in one case. And that results maybe in a conviction being overturned. And invariably what you have is a bunch of other people who had that prosecutor or who had that officer try and claim, well, my conviction should be overturned as well, because if he was corrupt in that case, he might have been corrupt in my case. And maybe he was, but that's not enough. It's not enough to show this person is corrupt. You have to show that they actually had some effect in your case. And you see that a lot in those corruption cases. And you hear people cry out about corruption a lot, but actually proving, showing that something happened in your case, that's where it gets hard. And this, Harpootlian, he's a very good showman. And he did a really good job at the beginning of this. You know, he had the big press conference and they filed a very well-written brief attacking Becky Hill, and they really went after her. And I think they had some good punches that they threw at her, and they probably landed some. A lot of what they've accused her of, maybe not all of it, and maybe none of it. I mean, I'm not sure. We're going to learn more in this evidentiary hearing, but there are definitely things that she did that seem like they're a little questionable. And I think they did a really good job of inflaming public opinion on that point and making a lot of people believe this was just sort of entirely corrupt, everything that was happening. And it was entirely corrupt because of Becky Hill. But where it gets hard is when you are asked by a judge, okay, that's great, but tell me specifically what happened and what exactly was it she did and which particular juror was influenced. And when you have to do that, it gets a lot harder. And I think you saw that today, that once you really start to talk about that kind of thing and have to lay out specifics, that's where it gets hard. It's very easy to write things in a brief. It's much harder to back them up when you got a judge asking you questions.
That's right, Brett. Well, that was today's preliminary hearing, which there actually was a lot to discuss. So, this 3-day hearing or potentially less than 3-day hearing is coming up at the end of the month. And of course, we will cover it when it comes.
Yeah, we absolutely will. And look, maybe at the end of it, there'll be a new trial because they will show all the things we talked about. But the challenge to the defense is much more difficult right now than it was this morning.
I think that's right. Yeah, we have not decided because we don't know what the facts are. It is very possible. All you need is one juror, actually, to say, I was absolutely influenced. All it takes is one. Doesn't have to be all 12. Doesn't even have to be 2. Doesn't have to be a majority. But what we have seen when you ask jurors these questions, especially jurors who've sat through very long trials with the amount of evidence that was presented in this case, I think it is a very, very tall mountain to climb for the defense here. But we've been surprised more than once in this case, so we'll see what happens, Brett. But before we sign off, is there anything else you'd like to add?
That's all I got. Stay tuned. It's not over yet.
It's just the beginning. Well, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
And then I'll record on here when you're ready to go live.
We're going live?
Well, no, but I mean, we're going to upload this to YouTube, so...
Oh, then maybe I should take my comforter down.
So don't look too ridiculous. Yeah.
I was trying to look ridiculous. Okay, let me think of a descriptor.
Don't freeze to death.
I'm like drawing a blank, man. It's too cold. Okay, I'll think of something.